Supreme Court had a ruling, I guess this was actually 2 days ago. It was a review of a Lexington, Kentucky case. Kentucky v. King. Basically what happened is the cops saw a drug deal taking place in a parking lot. They rushed into the apartment complex. I guess, I don't know if they were on stakeout or what, looking for a suspect who'd sold cocaine to an informant. I guess it was a sting operation. But the smell of burning marijuana led them to the wrong apartment. They knocked on the door. They announced that they were cops. They then claimed they heard sounds from inside the apartment that they said made them fear that evidence was being destroyed. They kicked the door in and found marijuana and cocaine, but not the original suspect who was in a different apartment. When a case goes to the Supreme Court, the facts are in no way reopened. So that these facts stand. It's not a question of whether or not they actually did smell it. It's not a question of whether or not they actually did fear that evidence was destroyed. All those things are stipulated. The Kentucky Supreme Court said this evidence is inadmissible because any risk of drugs being destroyed, remember, there's no warrant here. And we have a Fourth Amendment, which protects privacy and says that you need, you need reasonable search and seizure. You need a warrant. So there's no warrant here. And the Supreme Court said the evidence is inadmissible because any risk of drugs being destroyed was the result of a decision by the police to knock and announce themselves rather than obtain a warrant. What they're referring to here is there are circumstances where you do not need a warrant to bust into someone's house. These are called exigent circumstances. They have been found over and over again that should be a very narrow definition of what these circumstances are. They are limited to emergency situations demanding an immediate response to prevent serious injury to the arresting officer or other persons. The exigency exception can excuse a warrant for an in-home arrest when the probable cause exists and there is a compelling reason for not obtaining a warrant. For example, a need to protect an officer from danger or a need to avoid the imminent destruction of evidence when entry in hot pursuit is necessary to prevent a criminal suspect's escape, to respond to fires or other emergencies. This is from case Fisher. But the argument is that cops can't go around and create these circumstances. Because if they could, then the notion of needing a warrant really wouldn't apply. You can't, cops can't run into a building, I guess, and say, like, put one of the other cops on a ledge, have him there hanging by his hands, and say, we got to bust into the suspect's apartment so that we can save the cop. And they also cannot go around and bang on everybody's door and say cops and wait until they hear somebody shuffling around in there that sounds like they're going to destroy evidence. However, that's not what our Supreme Court found. The Supreme Court found they do not need a warrant to enter a home if they smell burning marijuana, knock loudly, announce themselves, and hear what they think is the sound of evidence being destroyed. The Supreme Court ruled on Monday in an 8-1 decision. Remember, I've said over and over again, the Supreme Court, since mid-50s, has, in every appointment, no matter who was being replaced, has moved to the right. Narrowing our civil liberties, expanding the rights of corporations, and make no mistake about it, you know, the so-called liberals on the court are not liberal. They just are liberal relative to those Neanderthal nutjob movement conservative types that sit on that court. Justice Ginsburg, in dissent, wrote, "The court today arms the police with a way routinely to dishonor the Fourth Amendment's warrant requirement in drug cases. In lieu of presenting their evidence to a neutral magistrate, police officers may now knock, listen, then break down the door, never mind that they had ample time to obtain a warrant." Alito,
surprise, surprise,
took pains to say that the majority, this is the guy who said that that young girl, I don't know if you remember this case, could be strip searched for virtually no reason, that the majority was not deciding whether an emergency justifying an exception to the warrant requirement in exigent circumstance actually existed. He said that the Kentucky Supreme Court expressed doubt on this issue, and any question about it when an exigency actually existed is better addressed by the state court. All the Supreme Court decided, Alito wrote, was when evidence must be suppressed because the police had created an exigency. So in other words, it's okay that the cops created it. It's okay. So the issue isn't whether or not they actually created this. They're basically, they say that the state Supreme Court can make that determination because that's more of a factual determination. They're simply saying that even though the cops created it, they could take advantage of that to attack your Fourth Amendment rights. Ginsburg went on to say, via the Lawyers, Gun, and Money blog, the question presented, may police who would pause to gain the approval of neutral magistrate dispense with the need to get a warrant by themselves creating an exigent circumstance? I would answer no as the Kentucky Supreme Court. The urgency must exist, I would rule, when the police come on the scene, not subsequent to their arrival, prompted by their own conduct. So that's basically it. I mean, under this ruling, if you thought there was some guys smoking pot in apartment 3B, you could send a cop up to the roof, have him hang down by his fingernails, bust in there to ostensibly to save the cop, and then bust everybody in there. She writes that the heavy burden has not been carried here. There was little risk that drug-related evidence would have been destroyed had the police delayed the search pending a magistrate's authorization. In other words, the cops, they smell pot, they go get a warrant. As the court recognizes, persons in possession of valuable drugs are unlikely to destroy them unless they fear discovery by the police. They had no fear to be discovered by the police until the cops decided to knock on the door. Nothing in the record shows that prior to the knock on the apartment door, the occupants were apprehensive about police proximity. How secure do our homes remain if police, armed with no warrant, can pound on doors at will and on hearing sounds indicative of things moving, forcibly enter and search for evidence of unlawful activity? Well, there you go. So you're in your house, you're listening to your music, Matt, that I think it's probably a question as to whether or not you actually downloaded that properly, or maybe you've received a BitTorrent of a movie, or maybe you're watching Justin TV and they've got MSNBC playing on there. Cops knock on the door, you shut your computer down. Uh-oh, they can come in.